think so. So, anything on your mind? Okay. We had gotten this far, kind of, in our discussion, sort of nailing down these KRS provisions on homicide. Talked about intentional murder, which is KRS 507.02001A. That if you, with intent to cause the death of another person, you cause the death of that person or another person. You have the mens rea of intent to kill someone, actus reus of killing that someone, or unlucky bystander. Okay? And what's going on here? Does everyone think that class doesn't start at 10:25? Okay, that better not happen again. Okay, be here on time, be professional. Obviously, anybody who was in their seat and was here on time, I'm not directing that at you, but that should not happen. You shouldn't have other people coming in after the time class is supposed to start. Okay, intentional murder. Except when? Except when is what would otherwise be intentional murder, not intentional murder?
Extreme emotional disturbance.
Except EED. And what is the consequence if there is EED?
First degree manslaughter.
First degree manslaughter. What part of 507.030 is that from?
B.
I'm sorry?
B.
B. So call it number 2. When a homicide would be intentional murder, but is not because of EED. Okay? So the connection between the definition or the exception in the definition of intentional murder links up to nicely and with a perfect harmony with part of the definition of manslaughter. So if you get your client off by convincing the jury that there was extreme emotional disturbance for which there was a reasonable explanation or excuse, you have effectively convicted him or her of manslaughter. Okay? So there's good news and there's bad news. Okay? There's good news and there's bad news. Okay, what's the other form of murder? Other than intentional murder? Ma'am.
Premeditated.
I beg your pardon?
Premeditated.
Where do you get that?
It wasn't on the KRS.
Where do you get that in the KRS? We're talking about the KRS right now. It's Clemens.
Wanton murder?
I'm sorry?
Wanton murder?
Wanted murder. And how is that defined? That's in section 1B of 507.020, wanted murder. And what's that?
So it's where you have conduct which
A little
creates,
louder.
there's conduct that creates a grave risk of death to another person.
Conduct. And where do you get wanted from that?
If he wantonly engages,
Wantonly engages in conduct. Which creates a grave risk of death and
actually causes the death.
and causes death, because you can't have an actus reus of homicide. You might have attempted homicide. We'll talk about that. I mean, you can't really attempt wanted murder, but you can't have a grave risk of death and causes death. What about that first clause in subsection B?
The operation of a vehicle under circumstances manifesting.
How would you
extreme
interpret
indifference?
that clause as part of the definition of wanton murder?
Could that include like drunk driving?
It might. What does it say? Read the whole thing.
So, including but not limited to the operation of a motor vehicle under circumstances manifesting extreme indifference to human life.
What is, grammatically, what is the purpose of or the meaning of that section, that clause in the section?
The manifesting extreme indifference.
Does it change the definition of wanton murder? Or if so, how does it change the definition?
Well, for the second part, it's like you're specifically creating a risk of death to another person. So it's almost like you have to be engaged in something with another person. But
Does it establish a mens rea?
No.
I was going to say it lowers the mens rea requirement.
No, it doesn't change the mens rea. Doesn't change the mens rea.
Yeah, so it's still malice aforethought.
No. Here, that wounds me. It's just wantonness, right? This is just wantonness. There's nothing that doesn't change anything about wantonness, right? What is required for this, as the name suggests, is that you wantonly engage in conduct. What does that first clause do? What does it change, if anything?
Maybe just like shows the prosecutor this is what they should charge people with, that they engage in like a reckless use of a vehicle that kills someone.
Why do you, let me put it another way, why do you think it's there?
Because otherwise they need to go for manslaughter.
In what circumstance?
In the circumstances of the operation of a motor vehicle.
And why might they go only for manslaughter? You're right on it. Bring it home.
Because
What might lead them to only go for manslaughter if that phrase wasn't there, if that clause wasn't there?
because they don't feel as though there's the mens rea.
No, it's not.
The competence of the jury might convict.
It's not about juries, although maybe. It's about what courts had said before. Sometimes legislatures react to what courts say. And courts in Kentucky, the Kentucky Supreme Court in particular, had said, we're not going to accept cases of basically really reckless driving, really dangerous driving, dangerous drivers that cause in awful circumstances things they do. We're not going to allow that to be murder. We're going to, if there's a conviction, we're going to reduce the conviction or require a new trial. So the Kentucky legislature was not very happy with that. And they said, we want to make it clear and explicit that this definition is not limited to circumstances involving operation of a motor vehicle. It's not limited to that, but it sure includes that. So don't make the mistake of thinking that that's the only circumstance that can be wantonly engaging in conduct creating a grave risk of death. But the General Assembly was emphatically telling the Kentucky Supreme Court, in circumstances where the driving is really egregious, how egregious? Manifesting extreme indifference to human life, that is included under this umbrella. Again, not the only thing under this umbrella. So when you interpret a phrase, when you say that word including, that's your immediate signal that something is there, there's some reason the legislature was clarifying this is part of that. Not the whole of that, but it's part of that. So how does that part change this definition? It emphasizes one aspect of it. Okay, it doesn't change anything about wantonness or what conduct has to be. It just says this is an example of that. There was the cases are particularly egregious, usually simply a simple quote-unquote DUI. If that's all that's involved, obviously there has to be a death, is not going to do it. But if you pair a DUI with, say, driving on the wrong side of the road and driving too fast and running a red light or some combination of those factors, you can sort of tease out what the circumstances might be that would make it particularly egregious. How egregious? Manifesting extreme indifference to human life. There the prosecutor gets some flexibility, some discretion. Oh, I might want to charge this as wanton murder, and maybe we could end up pleading down to manslaughter, but this is available. It does fit under this definition. Okay, questions about murder in general, wanton murder in particular, any of it?
Would the wanton look more like in a fact statement or something? Would it look more like manslaughter then instead of intentional, or?
Well, it certainly, it's not as clean a break as intentional murder. Intentional murder, we can say that's sort of the classic case that we think of. When we think of murder, when we think of things like malice aforethought, when we think of things like premeditation, at least there's overlap between that and intent. The law starts to get really fuzzy once you get into non-intentional mental states and still call it the same crime, right? How can wantonness be murder when intentionality is murder? Well, both of those are alternative routes to convicting somebody of murder, and yet this mental state can also be only manslaughter. And at that point, you just have to throw your hands up and say, it gives prosecutors flexibility in when to charge. Yes, some versions, as we'll see, of manslaughter involve this exact same mental state. So buckle your seatbelts and recognize that and see that both might be possibilities where the circumstances justify a charge of a conclusion there is wantonness, and then it can be either this, if the conduct creates a grave risk of death and results in death. Maybe it's not. This part isn't present if it's manslaughter.
Do some jurisdictions, is that what they call first and second degree? Like,
In some jurisdictions, the distinction between first and second degree is the presence of premeditation. So it's not intentional or wanton, right? It's premeditation versus mere intent. Some jurisdictions it is.
okay.
First and second degree is differentiated by intentional or wanton. What does that emphasize? You have to know the law in your jurisdiction because it differs. We're concentrating on Kentucky for obvious reasons, right? But these are not universal distinctions between these offenses, nor do universal labels apply to the distinctions. On the exams, since of course all of you are worried about that, understandably, I will tell you what law applies. I will either tell you Kentucky applies, the Model Penal Code applies, or I'll give you a statute. You will know what law applies, so you shouldn't worry about it for that purpose. But for practice purposes, know your jurisdiction, obviously. It's Clement.
We just did a case in torts where we had two people drag racing, and one of them was passing someone and hit a car and killed someone. So
No, you had that in criminal law.
Well, but if would that constitute wanton murder?
Okay, Ms. Prosecutor, answer your own question. What would you charge that as?
I mean, I would charge them with that, yes, because I'd say their conduct created a grave risk of death and
Okay.
caused death in that person.
Okay.
So can you be charged criminally and civilly for the
You don't
same
get
thing?
charged civilly. You get sued
okay.
by a plaintiff who was harmed, right? So presumably in the case where death resulted, the estate of, what was the victim's name in your case?
Yeah, Rogers.
Rogers, estate of Rogers versus Doofus. Whoever the
His
defendant
name was Race, actually. His last name.
No way.
Yeah,
Yeah.
that's crazy.
Mr. Johnson, you made that up.
No,
No, he's not
Shake
making
and
it
bake.
Okay,
Shake and
so it
bake.
would be estate of Rogers versus Race. Or it could be Commonwealth versus Race. That would be the criminal case. The same set of events could lead to a criminal charge, and it could lead to a civil suit. Of course, yes. But I wouldn't call it charges in the civil action. That's phraseology is just a little off.
In the KRS, what's the difference between wanton murder and reckless homicide? So it doesn't really.
Boy, you jumping. You want to jump right past manslaughter, I can tell.
Well,
You're like, I don't like manslaughter, I want to go to reckless homicide.
manslaughter is, I feel like, obvious, like it's a peg down from murder. But homicide, what's the difference between homicide and murder? Is that not?
I'm sorry?
The reckless homicide sounds exactly like wanton murder.
What is reckless? If you want to go there, we can do that. What does reckless homicide say?
A person is guilty of reckless homicide when with recklessness he causes the death of another.
So what's the difference between that and wanton murder?
I mean,
You just said it yourself.
I guess it just isn't creating a grave risk.
No? Well, yes, that's in there too. But what's even more, before you get to that, remember your mens reas
Or the non-clean days of conduct
versus
versus
Those are two different mental states.
Okay.
One is more serious than the other, right? Wantonness is you're aware of the risk and you decide to take it anyway. Recklessness is wantonness is the risk is virtually certain and you took it anyway. Recklessness is a shade below that.
Okay.
Okay? So it's a different mens rea. But I want to do manslaughter first. You can't just skip it, much as you might want to. What's the first kind of manslaughter?
When you are trying to cause serious physical injury,
So it's intentional, but it's a different intent.
Right.
To do what?
cause physical injury, not death.
Serious physical injury. So instead of wanting to cause death, right, that's what's intentional murder, you only intended to do injury, but you didn't know your own strength. Or, it spun out of control. Or you only wanted a wound, but you caused death. So there's your actus reus. You caused death. So it's a crime of intent, but a less egregious intent. And here's a good example. You can see where the seriousness of an offense and your culpability for punishment varies depending on your mens rea, right? This is a less serious mens rea. It's intent, but you intended to do something less, so we punish you less.
So I know we talked about suicide and how there's questions of whether the victim's voluntariness of his acts kind of negate the
In the Stevens overhold
defendant's culpability. Am I saying all that right? Okay, so when you say physical injury, it just made me jump to, where is the law in emotional injury that causes, kind of actions that result in death?
Right. The problem under the KRS, I think there's a pretty good chance that Stevens in the Overholser case would not have been convicted of murder, or for that matter, manslaughter, or certainly not intentional murder or this kind of manslaughter, because you could argue he didn't intend to cause serious physical injury. Now, if I'm the prosecutor, I'm going to argue that the other way, and I'm going to say he did, through his actions, intend to cause serious physical injury. Maybe he didn't intend death, so I can't get this, but I can get certainly first-degree manslaughter, right? Because he intended to injure her through the kidnapping, through the assault of sexual assault, and that was an intent to cause injury. It spun out of control. It caused death through her actions, but that he takes, since he put her in that state of mind, he has to bear that consequence. So that's how I would argue it as the prosecutor. I might also charge wanton murder, right? That his actions were wanton, that they created a grave risk of death. That would be a jury issue. Did the jury agree that his conduct, his whole course of conduct, created a grave risk of death? And then the jury would have to decide that. So if I was going to charge him with murder under the KRS, I think this would be my best bet. Okay? All right, what's the other kind of manslaughter? We already talked about that. Actually, that would be the third time, is C. Homicide would be intentional, but for the presence of EED. What's the second kind?
Intent to cause.
No, that is B. I'm sorry. That's B.
Oh, wait.
What's the third kind?
It's intentionally abusing or knowingly permits another person to abuse and cause the death of a person under 12 years of age, or who is physically helpless or mentally helpless.
There you go. Okay. It would not otherwise be murder, but you intentionally abuse another person or permit that person to be abused and causes death when the person is 12 years old or otherwise physically helpless or mentally helpless. Okay? Everyone see the manslaughter possibilities? So it would guide you as a jury. That's manslaughter in the first degree. What about manslaughter in the second degree? That's 4 though, right? Yep, manslaughter is the second degree.
Wantonly causes the death of another person, including but not limited to situations where the death results from a operation of a motor vehicle.
What's the difference between that and wanton murder? Indeed, it even says including operation of a motor vehicle, the same phrase we saw with wanton murder, sort of.
Is it extreme indifference to human life?
Good, excellent. Right? Now, whether that really gives you a difference is questioned. But this is the phrase of difference. But since the mens rea is wantonness, you could certainly argue that already encompasses the idea of creating a grave risk of death. But that's what it means to be wanted in this context. So it gets really fuzzy, the difference between second-degree manslaughter and wanton murder. This seems to create a difference, but you could argue that it really just gives prosecutors the chance, if they think a jury would buy it, if they think the jury would think that the circumstances are especially egregious, to go for wanton murder, and then second-degree manslaughter becomes the fallback. Mr. Webb, did I see your hand? Okay, so including operation of a motor vehicle or
Leaving a child under the age of 8 in a motor vehicle under circumstances which manifest an extreme indifference to human life.
and here we see extreme indifference to human life manifested there. And we've all seen cases, read about cases where a parent or a guardian goes into a store, leaves a child in a car, and tragedy ensues. And the question becomes, do we think that's a subject for the criminal law? Always, sometimes? Is it does a parent need the death disincentive? It's hard to say, but the law clearly gives prosecutors that leeway, that discretion to charge in those circumstances. Okay, any questions about manslaughter in general, first or second degree, under the KRS?
Just kind of about wanton in general. In Kentucky, it looks like it's kind of geared towards vehicle stuff. Could you give another example, just for the application of it?
Let's see. You decide to start shooting your gun in the middle of a downtown street. You don't intend to kill anybody, but that's really, really dangerous conduct. Maybe you're drunk. You're like, I have my Second Amendment rights, and I'm going to exercise them right here, right now, and no one's going to stop me. And so you start shooting your gun, okay? It's obviously not in your Second Amendment rights. Good luck to you when you raise that. And you kill 2 people, shooting haphazardly, right? If anyone wants to dispute that, we can have that discussion. We can do that. But I would say, as a prosecutor, my first instinct would be I could make a really good case that was wanted conduct. And let's say it results in death, we've got it. And is it extreme indifference to human? Does it create a grave risk of death? I would say yes. I would go with wanted murder. If I had to settle for second-degree manslaughter, maybe I plea that. I doubt it. I think I'd be pretty aggressive in that circumstance, but I think it would be a good example of wanted murder.
And that wouldn't be reckless because
because it's way worse than reckless. It's all about the mental state.
So, again, could you just explain the difference between wanton murder and manslaughter in the second degree? Because both phrases, both have manifesting extreme indifference to indifference to human life.
Well, only for this part of second degree manslaughter.
Okay.
That's only,
So-
that phrase is only in the second definition.
So-
What happens, I'll answer in two ways. The first answer is be cognizant of the legislative process and how legislatures work. This gets added later, after there are a run or a few cases in which this happens, and members of the legislature feel this intense political pressure to do something, to add some language to the penal code that gives prosecutors the chance to prosecute these cases. So they don't think carefully about, well, how does the language fit, and is it consistent with, or does it create overlap and duplicative language with this? They just add it and let the court sort it out later. And that leaves you guys with this perplexed looks on your face, understandably, that, hey, this seems to describe the same conduct. We got wantonness, we got extreme indifference to human life, grave risk of death, and extreme indifference to human life over here. It's the same thing, except it's a different crime with different punishment, different seriousness. And the answer is that's just how things get added to end up mucking up the code in ways that don't necessarily seem coherent, but capture what legislatures do and how they operate. Okay? So, is it really different? I don't think it is, but you have to, as a prosecutor, your focus has to be on, can I prove this charge? Are there facts that I could convince a jury, when the jury gets the instructions from the judge, that fits this charge, right? It's not an either-or proposition. You can charge both. So if you think there are facts from which the jury could be persuaded that the conduct was wanton, that it created a grave risk of death, right? And with operation of a motor vehicle constituting extreme indifference to human life, then you're going to charge that. Then you're going to look over here and you're going to say, well, leaving the child in the car is a little different than operating the motor vehicle, but you could say it's kind of, that certain facts might fit both. Did they leave a child in the car? Was it wanton? Did it manifest extreme indifference to human life? I can prove that. And if I can prove that, I can bring that charge.
So if we have something that fits into both of them, like a fact pattern, then you could charge both?
And then the question is, we talked about this on Monday.
You could charge both.
But how would you go about making that decision?
What you think the jury would do.
Whether you think tactically it makes sense to charge both.
So is there a difference between like the burden of proof that you need between the two?
What's always the burden of proof?
Beyond a reasonable doubt.
Nope, right.
So,
Can you prove each of the elements of each offense separately beyond a reasonable doubt? Now, if the person is convicted based on the same facts for both, they can only be punished for one. And we will talk about that later on, right? But you can charge both, because if you're uncertain, yeah, I'm almost positive we can get second-degree manslaughter, but wanton murder would be a stretch on these facts. So I'm not going to bank everything on wanton murder. I'll charge both. Let's say you end up winning both, you'll only get punishment for wanton murder, unless you have independent facts that are distinct for the two crimes. Then you can get punishment for both. But if you're relying on the same factual pattern to prove elements of the two crimes, you can only get punishment for one, so they'll be sentenced for the more serious one. It's called the whole doctrine of lesser included offenses. But don't worry about that for now. Okay?
Is the reason that they added the leaving a child in a car under 8 years for the second-degree manslaughter just because that could fit into wanton murder, but they don't want to charge parents with murder?
No, I think the problem was, is that really operation of a motor vehicle for that part of it? Because presumably you're not operating the motor vehicle anymore, you're leaving it behind. But then the question is, because it's not limited to that, it only includes that, is it creating a grave risk of death? Defense attorneys would say, you know, it was not that likely to happen, so it wasn't a grave risk of death, but it could manifest extreme indifference to human life. So that could be the way prosecutors, the legislature thought it was filling a hole. And then they said, okay, well, where should we put it? How serious is it? Is it murder or is it manslaughter? We think it's manslaughter.
So if you have like an abusive parent who wants to punish their child by locking them in the car for an hour in the hot sun, like
Right.
that goes into wanton murder, right? Because that
wow.
because
I
I would
thought
say
about
that
one.
creates a grave risk of human death more than just.
Yeah, I think you can make that case. I don't even want to contemplate trying that case or that's, I mean, yeah, I would, if I'm a judge and the defense moves to dismiss that indictment, my answer is, I would say, you know what, that's operation of a motor vehicle. It's operation not for its usual intended purpose, but we shouldn't construe that broadly. You're using that motor vehicle for a purpose, punishment of the child. That's operating it, and it created a grave risk of death because, I mean, part of it might be how long you left the child in there, et cetera. The defense would probably argue, I'm just sort of thinking out loud in response to this because I had not thought about it before. The defense would probably argue that it doesn't create a grave risk of death because the parent is conscious of the child being there as opposed to leaving the child unattended and unaware, which is riskier in its own way, right? Because if you don't remember that you left the child in the car and you go into the target and you're there for an hour in a summer day, that's a huge risk. But if you just if you're punishing the child, right, you're presumably aware of the child's presence in the car. All these issues would have to be sorted out. Make a great hypothetical question for an exam, Ms. Cummings. And you're like, I hate you so much. One more, we gotta start moving to the cases.
Why do they say under 8 years?
What do you mean?
Well,
because why do you think this legislature might have said under 8 years?
I mean, I would say that's more common, and a child under 8 can't get out on their own, and maybe a child 8 and up, you know.
Why
in the streets
is
of
the
Kansas.
line 12 or 14 or whatever it is in the statutory rape sections? You have to draw a line somewhere, right? The law, any time age is involved, why is 18 to vote, right? Why is 18 the drinking age, or 21 is the drinking age, right? You draw lines, and presumably the legislature had testimony or evidence about capacity and risk to children, that especially young children are at greater risk. All right, we gotta move on. We gotta start talking about the cases, because we're gonna fall hopelessly behind. So let's talk about Francis against Franklin, okay? I want to suggest to you that Mr. Franklin is at once both the most clever inmate we've ever seen and the dumbest. And that is a very rare combination, okay? Why do I say he's clever? What about these cases, you read the facts, made you think, wow, this guy is the sharpest tool in the shed?
I would say after he got to Collie's house.
No, this is before Collie's house. Once he gets to Collie's house, he acts dumb as a rock.
I think he actually acted intelligently.
Well, we'll see. We'll have that discussion, and I'll win. Actually, I have no idea if I'll win. But what before he gets to the Collie's house?
I mean, he managed to get the dentist's keys without the dentist knowing.
He's released from his shackles when he goes for dental treatment, right? Because they have to treat him, and he manages to escape by getting a gun from one of the guards. There were 2 guards, both armed, and he manages to get away. Right? So the escape itself, that's pretty darn impressive. And does he escape alone and thus subject to almost certain quick capture?
No, he takes a hostage.
He takes a hostage. No dummy he, right? He takes the dental assistant as the hostage. And at that point, things start to go, at least start to go a little awry. Little things start to happen. Ms. Morton, what happens next that causes a problem after he gets out of the dentist's office, has the dental assistant with him?
So he gets to Collie's house.
Right, before he gets to
can't
Collie's
get-
house. How does he get to Collie's house? Like, how does Red Riding Hood get
He
to grandmother's
walks.
house? How does Franklin get to Collie's house?
So on the way, he tried to contact a couple people, and I think they ended up walking him.
They ended up walking because he couldn't get into the dental assistant's car.
Like what? That's crazy.
Okay? So that's a problem. We're already like, okay, you're having this problem. And a local resident says, well, I don't have a car. So that attempt fails to get a car. So he's on foot on his way to Collie's house. So tell me about Collie.
So he gets to his house, he's an older guy, and he gets to the door. I think he had the gun in his face, was like, give me your car. And he slammed the door in his face, and then the gun went off.
So the defense would have you believe.
Yes. The gun
Yes.
allegedly went off when Collie.
Which is another way of saying Franklin fired the gun,
Right.
arguably, from the prosecution's point of view. And then what happened?
So when he slammed the door, the bullet went off, he went through the door and then shot Collie in the chest and killed him. And then the gun somehow went off again, and the bullet went up through the roof.
Through the door and into the ceiling this time, okay? Then what happened?
Then the victim's wife comes up and he asks the same of the victim. And this is when I think he got kind of intelligent, because he already knew he was screwed at this point. But I think he tried to make up for it, because when the victim's wife came to the door, and he asked her the same, well, didn't ask, but demanded that she give him the car keys, and she was like, no. He was just like, okay. So I think he was intelligent because he had the gun in his hand, and he could have used force. Like he said, that was one of his defenses. He could have used force, he could have threatened her, so on and so forth.
Did that defense end up working?
No, but I still think it was smart, because it could have been way worse than what it was.
All right, Ms. Morton, if I told you that I was going to spot you 30 points on the final exam, and you end up with a 52, what conclusion would we have to reach?
Well, first of all, that's never going to happen.
It's all hypotheticals. Okay? But if I spotted you the first 30 points, and you end up with a 52, what would you have to conclude?
You got 22 on your own?
You graded unfairly.
That Ms. Morton probably isn't a criminal law star. Right? She actually is, but this is the hypo. I'm positing, in my view of Franklin, that we spotted him 30 points. We spotted him a gun. We spotted him the danger of the threat. He's already now killed somebody, so this is somebody who will do it if you're a bystander. And yet, despite spotting him this 30 points, he can't manage to get a getaway car. Everyone he encounters says, "Screw you, pal," and just walks off. Collie's wife, right? Is Collie's wife the last one?
No, then
Oh,
their daughter did the same thing.
Their daughter's like, "Not scared of you, pal," right?
I know you just told me.
This guy is like, he's like the Keystone Cops, the opposite of the cops, of escapees. He can't get his act together, right? He can't get his act together. Now, Ms. Morton makes a great point that at least this gives him his lawyers some ammunition, no pun intended, to make the case that, wait a minute, all his actions refraining from doing anything bad to anyone show that he didn't have the intent when it came to Collie, that it allows us to raise an inference about his intent. That is, look, this was not an intentional killing. And that's really a good point. But overall, I think, man, you could have come up with something that could have given you a better shot at making this escape successful, okay? And it turns out not to be. It turns out very much not to be successful. And so it should be as no surprise that he ends up getting caught that night, okay? So he says, Ms. Morton, what does he say about the killing of Mr. Collins?
So he says it's an accident, and he, well, him and his lawyer raised 4 different defenses from what I found. Was that the door slam caused the gun to go off, and then the second time the gun went off, which I don't really understand how that went off unless it was also because of the door slam, that it went off into the door, into the roof, which means which could kind of show that it was an accident.
Sure.
And then-
And both of those together add up to what, they're sort of different facts supporting or leading to the same basic argument,
Yeah.
which is?
Which is, it was an accident, or he didn't intend to.
That exactly, that he lacked the intent to kill. The circumstances, the trajectory of the second bullet, his treatment of everyone else he encountered, they show that he didn't want to kill. Okay? Does that help him with the jury?
No.
And why was the what does he say was wrong in terms of producing that jury verdict?
He said that they didn't, so the jury requested a free instruction on the element of intent and the definition of an accident.
Yeah.
And I don't think they did it the first time, which is why the jury asked for that instruction.
And what did the judge tell him?
The judge gave the re-instruction, I believe, and then the jury still found him guilty.
There's something about the instruction that he challenges.
He challenges 2 sentences. The acts of a person of a sound mind and discretion are presumed to be the product of a person's will, but
Presumed to be the product. It says free will, but we're going to say Franklin's intent. It says a person's, but we'll just make it Franklin specific. Acts are presumed to be the product,
and a person of sound mind and discretion presumed to intend the natural and probable consequences of his acts.
presumed to intend the natural and probable consequences of his Franklin's act. Okay? What does the defense on appeal say is wrong with this?
Well, they say that because it says that the presumption may be rebutted, it makes it sound as though the burden of proof is on the defense instead of the prosecution.
What are the 2 possible ways a presumption could operate? Or what are the 2 kinds of presumptions?
Well, they can presume guilt.
2 different ones.
Rebuttable or not rebuttable?
Good. Rebuttable and irrebuttable. What is the, which, from a defense perspective, which is worse? It's called an irrebuttable presumption, because that would say you presume that he had intent by the fact that the act occurred, and presume it so strongly that it's a mandatory presumption, and the defense doesn't even get the chance to rebut it. So a rebuttable presumption is at least a little better. And this one was a rebuttable presumption, so we're not dealing with an irrebuttable presumption, because that would be even worse from the defense. So the defense has to say, even a rebuttable presumption is a problem. Why does the defense argue that it was a problem?
Because it still relieves the state of its burden of proof.
A rebuttable presumption means we have to rebut it. Right? And it's not that we're rebutting something that the prosecution proved by evidence, but something the jury was told it should presume. And if you're saying we have to rebut something that was presumed, you're basically saying we have to prove it. And you have shifted the burden of proof. Instead of requiring the prosecution to prove intent beyond a reasonable doubt, you're saying the defense had to prove the lack of intent beyond a reasonable doubt. And is that argument successful, Ms. Morgan?
Wait, what?
Is that argument for the defense that it was impermissible to use this presumption to effectively shift the burden of proof? Does the defense win with that argument on appeal?
No.
Does it?
It's remanded.
The defense wins. They get the conviction reversed. It says, yes, this would be worse if it was irrebuttable, because the prosecution's like, well, they can rebut it. What's the big deal? And the court says, no. Yes, an irrebuttable presumption would be worse, but a rebuttable presumption is bad enough. It relieves the prosecution of the burden of proof that it cannot be relieved of. Okay? But the court tells you something important about on remand. Okay, we're not going to use presumptions. Presumptions are bad, but what the court says something about how the jury can find intent that I want to distinguish from a rebuttable presumption. What does the court say about how the jury could, at a new trial, find intent?
Could they infer from the facts?
They can infer. Very good. An inference is different from a presumption, right? It says, because juries are told all the time, ladies and gentlemen of the jury, you may infer that X was there from the totality of the evidence. In this case, that intent was there from the totality of the evidence, right? And so they may draw an inference, they just can't in doing so, operate on the basis of a presumption that puts the burden on the defendant. So this inference is about how the state or the prosecution fulfills its burden of proof beyond a reasonable doubt. Whereas a presumption would shift the burden of proof. An inference is about the how the state fulfills its burden. It's written.
So are presumptions never allowed in criminal cases?
I love that you asked that question. We did not set that up in advance. The answer to that is they are not allowed as to any essential element of the crime. Okay? Let me give you an example. EED, or its absence, is not an essential element of murder. What are the essential elements of murder in Kentucky? Intent and the taking of a life. So if Kentucky wanted to say, okay, defendant, you want to raise EED, you have the burden of proof on EED. Kentucky could do so. The things that you cannot shift the burden of proof, with either making it an affirmative defense or creating a presumption, are the essential elements of the crime. That's what you can't shift the burden of proof on. Now, it so happens Kentucky has not shifted the burden of proof on EED, but they could. And most states have shifted the burden of proof on EED to the defense. Okay, so that's an example where you can shift the burden of proof. The question is it an essential element of the crime? And that often leads to litigation over whether this or that issue in the case that where the trial judge did shift the burden of proof or allow a presumption. The defense argues on appeal that was an essential element of the crime. You shouldn't have allowed that shifting of the burden of proof. And those get resolved both ways depending on the issue and the state. But that's the criteria. Is it an essential element of the crime? Okay?
So,
A little louder, so everyone else can hear.
So, in the case it talks about the 14th Amendment and the due process clause, and how that could be violated with the defendant's criminal intent.
What they're saying, what the defendant's claim is, what's the source of the defendant saying, hey, you can't shift the burden by creation of this presumption. And the source of that right, what the defendant is saying, doing so violates, is due process. The due process clause of the 14th Amendment. So otherwise, in other words, what is the limit? What provision of law creates the limit on the state's ability to decide, hey, we're going to shift burdens, we're going to You know, we're gonna say, once a charge is brought, if a state wanted to, it could say, defendant, you have to prove you didn't kill the person. You didn't have the intent. We'll put the burden of proof on you for every part of the crime. What limits the state's ability to do that? The due process clause of the 14th Amendment. That's where we get the right the defendant has to say, our notions of due process require this, that the state meet the burden of proof, that's a shield that defendants have against abuse of authority and against unjust prosecutions. That's a function of due process.
Did they just say, like, you're not allowed to have jury instructions that have the effect of relieving the state of the burden of proof, instead of you can't instruct the jury to make presumptions because they wanted it to be broader?
Well, anything you do could, like making an affirmative defense, for example, would have the effect of shifting the burden of proof. So they weren't just limiting it to presumptions, that's just one mechanism by which. The problem with what the court is saying is that the problem with presumptions is not anything about them intrinsically. The problem is they have this effect of shifting the burden of proof. So anything else that shifts the burden of proof on an essential element is equally problematic. Okay? All right, let's talk about Watson. Two police officers are investigating the theft of a car, and they saw it. This is sort of like the top coat, right? Wow, I just saw the top coat for the crime I'm investigating. Timing is great, coincidences are wonderful. So they order the driver to stop, saying, police, hold it. You can all imagine that. You can all imagine from cop shows. That's the way things happen. Police freeze, something like that. And so our friend Watson jumps out, looks at the officers, and doesn't say, you know what, I'm going to get myself in bigger trouble. I should just surrender now. No, no, no. He ran towards an apartment complex. Why did he do that, by the way? Well, turns out he does make a phone call, which was not smart on his part. But why does he flee the police?
He has drugs on him?
He's got drugs on him. And he thinks, I'm toast if they catch me. So he runs toward this apartment complex. Officer Lunning pursues. He finds, once he gets into an apartment, Watson finds 3 young girls, ages 14, 13, and 9, doing their homework. Some excellent parenting going on there. And he, as you say, that was Ms. Fields, right? You said that? Oh, it was Ms. Mwanga? I knew it was from that direction. He's asked to use the phone. And they say, sure, no problem with that. And he asked them, are they still out there? Meaning the police. And Lunning eventually gets to the apartment with his gun drawn, right? He told Watson he's under arrest. Watson responds, for what? Right? For what? He does not cooperate with being handcuffed. And Lunning says, what does Lunning say, Ms. Mwanga?
It's not worth it.
Now, he says that later. What does he say at first, Mr. Webb?
This is, I'll blow your head off.
Do you want me to blow your blankety blank head off? Now, this did not gain Watson's cooperation. Instead, he said, you're not going to put those things on me, and about that, Watson was entirely correct. He wasn't going to put those things on him. He instead grabs Lunning in a bear hug, and Lunning's gun drops to the floor. There's a scuffle, and it shouldn't be all that surprising that eventually Watson takes control of the situation, because he's 6'4", 218, and the officer is 5'9", 220. Right? So if you visualize those two people, you would expect that Watson is going to be physically in better shape and probably able to incapacitate Lunning. That's when the girl said that that Watson said, Lunning said to Watson, it wasn't worth it. But Watson grabs the gun and holds it to Lunning's chest. And the girls run to the bathroom, and inside they hear a shot. Another of the girls runs outside and heard the shot from there. She saw Watson coming down the steps as we were leaving the apartment complex and holding the gun in his hand. Lunning follows shortly thereafter, holding his chest, and eventually falls to the ground. The gun, the evidence shows, was fired from about 3 feet or so, 36 inches, from Lunning's body while he was lying on the floor. Watson went into another apartment on the same block, asked to use a phone. A witness heard him say, "Just shot the police. Could you come and get me?" Right? So he also needs a car. Right? That's the day.
That's a friend right there.
Huh?
That's a friend right there.
You got a friend in me.
An accomplice.
He said he had something on him and the police were chasing me, so I hit the Lunning with the gun. Another witness corroborates all of this, says Watson told her he was carrying drugs and offered her money if she would hide him. So what's the issue here? Ms. Fields? Is that your hand up?
My hand, but I didn't see.
Did that not look like Ms. Fields' hand was up?
My hand's always doing stuff.
See, now that, my hand's always doing stuff. Now that is something we can all learn from, right? Be very careful what pose you strike, because it can get you in trouble, right? What's the issue that he raises here?
He's saying that there was insufficient evidence of premeditation and deliberation.
Good. He's saying insufficient evidence of premeditation and deliberation. That seems a little redundant, premeditation and deliberation, but that's okay. Premeditation. Deliberation. Okay? Who wants to be Mr. Watson's defense lawyer? Premeditation, deliberation is absent. Premeditation, deliberation is present. We know who's going to take which side of each. Who wants to represent Watson and construct a story, a narrative of these facts, from which we should draw the conclusion that there was no premeditation?
Okay, I would argue that he was in the room and he was scared, and then the police officer came in and threatened to blow his head off, and then there was this scuffle and in a panic, without thinking about it, he shot him.
Without thinking. How do we know it was without thinking, according to what you will tell the jury?
That the girls
What
were.
would, or let me put it another way. What would be harmful to your case that would show premeditation or indicate premeditation that you can say isn't here? What would you normally expect to see in a case of premeditated murder that isn't present here?
A decision beforehand, or
What do you have to have to make that decision in advance beforehand?
like a manifestation of that decision,
Or?
Substantial steps, maybe?
No, not what I'm getting at.
Time?
Time is called?
A plan?
A plan. And if you're going to form a plan to shoot somebody, what would you normally expect to have?
A motive?
No, not a motive.
A gun?
A gun.
Uh-huh.
Watson wasn't armed. Right? If you're going to premeditate a murder, at least a murder by shooting, presumably you would be armed in order to carry it out. Right? Think about the sort of your archetypal case of premeditated murder. Again, assuming we're dealing with a shooting and not some other form of killing. Right? You're sort of, what you would normally envision is somebody who says, I want to kill this person, so they form an intent prior to the act, and so I'm going to have a gun when I encounter this person. But you're going to say to the jury, Watson wasn't armed. When did he become armed?
when the gun was loose and he grabbed it.
Only after the encounter with Lunning, after everything happened, right? So this is not a person, ladies and gentlemen of the jury, who planned to kill, who formed a plan that would result in the death of Officer Lunning. This is somebody who reacted spontaneously in the moment. The fact that he didn't even have a gun tells you this is not somebody who was planning to kill not just Officer Lunning, but anyone. Right? It all happened suddenly. And how much time are you going to tell the jury they should be looking for in order for premeditation to have been evident?
A reasonable amount of time.
A reasonable amount of time, right? The courts do not set any particular time, but this wasn't it. This was events happening in rapid sequence, and if we're going to distinguish between premeditated murder and what here would be second-degree murder, right? But depending on the jurisdiction, it might be the distinction between manslaughter and murder. Whatever the distinction is, it's not the most serious. It's not premeditated. That reasonable amount of time didn't exist, right? Okay, now I need a prosecutor. What's your narrative on these facts that goes the other way? Ms. Fields must be our prosecutor.
Not really,
And her hand was definitely up that time.
Yeah. Yeah.
Made no mistake this time. Go ahead.
So basically, the prosecutor is arguing that at the moment when
No,
they-
you're arguing.
Oh, yeah.
You're the prosecutor.
Well, I'm arguing at the moment that he was stopped by the police. He was thinking of a way to get out of it.
Time starts earlier than the defense thinks it does. Good. Right? Time starts once he encounters the police and runs from them, he's already thinking of alternatives, of steps he might take. And what's one of those steps he might take?
Running.
Not just, we don't care about running, what do we care about?
I guess getting the gun from the officer.
Or right, and one of the alternatives he might think of is, perhaps, if necessary, killing the officer or officers, right? Whoever comes after him. So he's thinking ahead. What else does the prosecution point to?
Trying to remember.
Wanda?
Well, that there was time for, the officer to repeat, it wasn't worth it, the girls had time to run out from the room. There was more time than what the defense is saying there was.
Time during the encounter. At one point he sits down at the table and has time to think about a plan, right? Time during the encounter to plan. Okay? So how do we resolve these competing narratives?
Jury.
I'm sorry?
The jury.
What do you mean by the jury?
Oh, well, I mean, so you've got two sets of facts competing, and so then the jury will decide whether it's been proved beyond
And the
reasonable
jury
doubt.
did
Correct.
decide what?
That he was guilty of first degree
And what
murder.
does the appellate court do with that?
Well, the defense had asked for a judgment notwithstanding the verdict, and the appellate court looks at that and they affirm the
How
verdict.
do they look at that?
They looked at that the jury could have found that there was a
Could have
reasonable amount of
found.
time.
I want to emphasize this about the appellate court's function. This is as good a case as any to really drive this point home. The court says in resolving these, the jury could have found. Now maybe you might think, maybe the judges on the appellate court think the jury was, they would not have reached the same conclusion. But the jury could have found this narrative to be right, based on all the facts. And how does the court go about weighing the permissibility of the jury's conclusion of its verdict?
They go through the conclusions and say that they could reasonably find that what he said after he made the phone call anticipated the officer's arrival
Okay.
and a plan of escape.
Again, I'm still talking about the way appellate courts regard and treat jury verdicts. Not in this specific case, but in general. Cannon?
They give deference to what they found in the trial court, right?
But that deference is, I want to go through the specifics of that deference, right? What is the court looking for?
Sorry. He's saying that the jury is entitled to consider all of the circumstances.
And how does the appellate court look at the evidence? Webb?
It says whether there is sufficient evidence from which a reasonable juror could fairly conclude guilt beyond a reasonable doubt.
And, give me more.
Most,
And
most favorable to the plaintiff.
You look at the evidence in the light most favorable to the verdict, to the jury, i.e. the prosecution. Drawing all reasonable inferences in favor of the prosecution. So at the trial stage, before there's a verdict, because of the presumption of innocence, all of the burdens, all of the procedural approaches weigh in favor of the defense, right? Because the prosecution has to prove beyond a reasonable doubt. That flips 180 degrees once you get to appeal and there's been a guilty verdict. At that point, you ask, could the jury, not was it right or wrong, but could the jury have found this? Looking at the evidence in the light most favorable to the prosecution and drawing all inferences in favor of the prosecution. So now the deck is stacked in favor of the guilty verdict. And if there's a not guilty verdict, it can't be appealed. Right? So we're only talking about cases in which the prosecution won, and now everything gets tilted in its favor, switching over from what happened at trial where the prosecution had the burden of proof. Now this is not the case if you're challenging the jury instructions, because that's a legal issue. But when you're saying the evidence wasn't sufficient, that's about facts. That's about were there sufficient facts to support the verdict on the evidence, and everything weighs in favor of the prosecution. Okay? So we might think this was the more plausible story, that there was no premeditation here. This all happened in too rapid a sequence of events. That this, in fact, you might think is kind of the case you would envision if you were trying to illustrate a case where there wasn't premeditation. Somebody just acting quickly in the spur of the moment, not really thinking ahead. But no, because of what the jury could have seen, and the appellate court spins out a narrative of how maybe he wasn't just acting in the moment, he had a lot of ability to be calm and rational even in, this adrenaline rush of a moment. And if he had that ability, or the jury thought he had that ability, the verdict is affirmed. Okay? So what does Kentucky say about premeditation?
I don't think they say anything, do they?
And so what does that mean?
That it's not an element of the
Good. Very good. Right? You can look high, and you can look low, you can look left, you can look right, you can look under the surface, you can look at the text. You will not find premeditation as an element of murder in Kentucky. Right? Premeditation, in other words, is not the basis on which we distinguish between the most serious homicides and the less serious homicides. We have intent, we have wantonness, we have all those factors. Premeditation is not the law in Kentucky. So don't make that mistake. Please don't make that mistake. For your sake, don't make that mistake. Every year on an exam, at least exams on which I include a homicide, a homicide component, somebody goes into a long, extensive discussion about premeditation. And I just go like, why me? And I feel bad for the person or persons. Don't be that person. Be the person who says, I'm not going to talk about premeditation because it's not an element under the KRS. So there's no reason you talk about it. I will not want you to show me you know something about premeditation, right, just to show me you know it if it's not applicable. Show me you can apply the law that applies.
So you also want us to show that we know that is, make that statement that...
No, I don't want you to even address it. I will not want you to even address it, because that will, because I don't want you to talk about things that are not relevant. one of the most important lawyering skills, this is a great, I'm so glad we had a chance to talk about this. One of the most important lawyering skills that you will need to have to serve your clients well is the ability to separate out what's irrelevant from what's relevant. And one of the ways I test for that is, do you talk about irrelevant things on the exam? That's why I want you to have a laser-like focus on the question I ask you. So if I give you the KRS, I might not. I might give you a statute that has premeditation in it, and then you'll have to say, okay, that is relevant now. But if I gave you the KRS, and you started talking about premeditation, just because you think you want to show me you know that you have that knowledge, oh, premeditation is not a requirement in the KRS, you will not get any points for that. What you will get points for is telling me, answering the question I asked you. Let's say I asked you, should so-and-so be charged with what should so-and-so be charged with under the KRS, right? There's no reason to talk about premeditation because you can charge the person even if they don't have it. And if you're the defense lawyer and you want to say, well, they can't charge my client or they shouldn't charge my client, you can't say it's because she lacked premeditation, because that's not going to get you anywhere. But show me you know what's relevant by not even addressing the irrelevant. That's what I want you to do on the exam. Call.
Can you use premeditation to prove intent?
You don't. Only if you're a prosecutor who wants to cause him or herself more stress, right? Because you're assuming a burden you don't need, right? All you need to show is intentionality, whether that intention arose in an instant or whether it was part of a long plan hatched 10 years ago and finally coming to fruition. You don't need to show it. Now, the facts that would support premeditation, if it were required, those facts might also show intent. So point to the facts. Say, we should charge, what was the person's name? Race?
Yes, sir.
Race? We should charge Race with murder because here are the facts that show Race's intent, right? But just talk about the facts and how they fit the legal standard. Don't bring in, we can prove premeditation, and by proving it, we prove intent. Because I'll be like, what? Why? Why would you assume more than you need to prove? No prosecutor wants to have to prove or even address more than they need to address. Okay? I love that discussion. It's really important that you know what I'll ask for, how I'll ask it, and how you should approach it. So that's really great. Okay? Okay, let me just introduce basically this the next case, Walker. We're going to get to it, but just to address it, it's about manslaughter, and it's our introduction to EED. Okay, it's our introduction to EED, and it differs from murder not in the outcome, somebody died, nor the intent. Right, the intent was to take a life. Indeed, was the purpose of the defendant. What does differ? What does differ in a case like Walker?
The circumstances in which the murder was committed.
What circumstances? Yes, that's true. The circumstances differ. What circumstance, Mr. Razor, differs?
Anything provoked or in heat of passion or heat of moment.
And that's our whole discussion of EED, and that is perfect. Perfect, Mr. Razor, because the envelope. A form of the word will do in this case, because we're right at the end of class.
I don't know, provocation.
Provocation. Mr. Razor said provoked, right? So the issue we will discuss starting next Monday is those situations in which you have EED, heat of passion, provocation, and how that distinguishes murder. It's not the intent, it's not the outcome, it's the circumstance of provocation. We'll start that with